Hello, my name is Nicole Braddock. I'm with the law firm of Murray, Plum & Murray, and I'm here with Dick O'Mara, also with Murray, Plum & Murray. We're going to talk to you in this video about the due process hearing procedure, which is the most formal of the three dispute resolution options that you have. You can refer to the other videos on complaint investigation and standalone mediation for more information about the other types of dispute resolution procedures. And one thing to note is that the stay put right is one that exists with all three options and is also exists with the due process hearing procedure. So when you file for due process, the student's placement cannot be changed by the district during the pendency of that proceeding, which is a very powerful right that the parents have. So until you have a hearing decision, and even if you appeal, unless you agree with the change, the district cannot do anything to change the child's placement at that time.
My name is Dick O'Mara, and I'm also from the law firm of Murray, Plum & Murray, and my job today is to tell you about the due process hearing. Now, this is a process which is close to what you would see in a court of law. It involves the filing of a complaint, it involves a formal response, it involves some discovery in most cases, and it involves a mini trial before a decision maker who is a third party that makes the decision in the case and takes the decision making out of the party's hands. That decision can be appealed through a judicial action brought in court where a judge would review the proceedings, but for the most part, most cases that go to due process resolve, if they're not settled, by a due process hearing officer's decision. It starts with the filing of a form, and the Maine Department of Education has a form that it has suggested is used by parties. It can be filed by the school district or by the parents, and by filling out this form, you need to send it to the other party, and then also with a copy to the Department of Education. The form allows you to select an opportunity for mediation prior to going to the hearing. And so if you would like to have that option, you simply check the box at the top that says yes, and before you ever meet your hearing officer, you'll meet a mediator and have a chance to resolve your dispute by settlement and negotiations rather than by a third-party decision. Assuming that the case cannot be resolved at mediation, then the case will move on and actually go through the formal proceedings that Nicole will discuss in a few minutes. When you're thinking about filing, you need to obviously focus on the disputes that you believe need to be resolved by the hearing. You're allowed to bring up in a due process hearing any dispute that is within the last 2 years, but the trigger date is 2 years from the date on which the parent knew or should have known about the action that forms the basis for the complaint. So in some cases where violations may have been concealed, that date may be much later than the date on which the action actually was taken. In addition, the rules allow you to go back 2 years before the date that you knew or should have known about the violation in order to cite violations in your due process hearing request. When you file that request, you need to be clear about all the facts that relate to the problem and about what you want to see happen, because if you don't put in those essential elements in your request form, the school's allowed to file what's called a sufficiency challenge, which basically says your due process hearing request is not clear enough to be understood. If that happens, and it has to happen within 15 days of the school getting your due process hearing request, then the hearing officer makes an initial decision within 5 days about whether the complaint is sufficient, whether it clearly outlines the facts and the violations that you think have happened. In cases where there's an insufficient filing, you get a second chance to go back and fix it and amend the complaint that you filed in order to start the process again, but all the timelines then move out, so you may not move through the process as rapidly. Also, the school district, assuming the parent has been the one that's filed, or the parent, if the school district files, has to file a response to the due process hearing request within 10 days of receipt. So if a school district ever files a complaint for due process against you, remember you have 10 days to file a response that states your position on those various issues. Once the complaint, the due process complaint has been filed and the hearing's been requested, there will be an opportunity for both sides to have what's called a resolution session. Now the resolution session is sort of like mediation, except there's no mediator. It's the parties getting together on their own, and the topic of discussion is supposed to be, how can we resolve the issues set forth in the due process hearing request? this has to happen within 15 days of the filing date, unless both parties waive the process, or unless both parties agree to go to mediation instead of doing the resolution session. Now, the resolution session, therefore, has to happen so long as one party would like it to happen. So in situations where the parent may not want to go to resolution, but the school does, the parent still needs to show up and participate in that process and come to the table with ways to resolve the due process hearing request and act in good faith. At the end of the resolution session, there's either going to be an agreement to resolve the dispute or no agreement. If there's no agreement, you'll move on to the pre-hearing and hearing procedures that Nicole's going to describe in a second. If you make a resolution agreement, however, you need to have that in writing, and it must be signed, and you must be clear that everything that's being decided as part of this agreement is on that paper, because things that are left vague or things that are left out will not be enforceable. The resolution session agreement itself is enforceable both through a state complaint or through the action in either a state or federal court, and those courts are allowed to enforce these agreements and make sure that what the parties agreed upon actually occurs. One other rule that's important to know on resolution agreements is that you have a 3-day rescission period. So within 3 days after having the meeting and signing that agreement, either party can come back and cancel their agreement without any consequences at all. The agreement becomes null and void, and you either make a new agreement or you move on to the processes which Nicole will now describe.
If you fail to arrive at a settlement agreement either through the resolution session or through mediation, you then have to move on to the pre-hearing and hearing process. When you, after filing your hearing request with the Maine Department of Education, they will send you who your hearing officer is, and then give you dates and locations for the pre-hearing and at least the first day of the hearing. These are dates that you can change if you need to. It typically comes with a form that if you cannot make those dates, you can send that back to the department to let them know that you can't make those dates. The department typically selects a neutral location for the pre-hearing and hearing, sometimes a DHHS office, sometimes a room in a courthouse. But again, you can also, by agreement of all the parties, change the location. Sometimes they occur in attorneys' offices or other locations. So the pre-hearing is essentially a time for the parties to get together with the hearing officer to discuss the issues of the case and to exchange documents. In advance of that, you need to prepare all of your documents together and provide them and bring them to the pre-hearing, any relevant documents that you find, and bring them to the pre-hearing. You also need to develop a witness list, and the goal is to be over-inclusive in your witness list. You don't have to call all of those witnesses at a hearing, but it's all people that you potentially might want to call. There's typically a document that you provide to the hearing officer and the opposing party at the time that can be a quick narrative of the issues of the case, the factual background of the case, your statement of the issues. So, for example, if it's an issue of you're seeking compensatory education, you'll list bullet point 1, did the district violate the student's right to a free appropriate education in the so-and-so school year, and then number 2, if so, what remedy is appropriate, is compensatory education appropriate, things like that. So you're really framing the issue of what the case will be about. The district will have their own statement of issues as well, and then the hearing officer will issue, after the pre-hearing, a memorandum where the hearing officer will list how they view how he or she views the issues of the case. And you can discuss those with the hearing officer if you don't think they accurately capture what you believe to be the issues of the case. And then again, this same document that you provide to the hearing officer will list your witnesses. So it's going to have a narrative, it's going to have your issue statements, and your list of witnesses. If you do not have all the documents that you need in time for the pre-hearing, pre-hearings are typically scheduled 1 to 2 weeks before the start of the hearing. You do have up until 5 days before the hearing begins, before the first day of the hearing, to provide more documents. So you can update your record if you need to. So that is the pre-hearing. It's typically short, maybe about a half hour to an hour, depending on what may come up. It's not It's not very long. And then the next thing that you have is the hearing. The hearing can last, we've had hearings last a couple of weeks. Typical hearing, it depends on how big the issues are. Sometimes they're 2-day hearings, sometimes they're 5-day hearings. It really depends. And the process starts by, you'll be sitting around at a conference room table. It is the most formal of the dispute resolution options, but it's far less formal than being in court. You're typically sitting around a conference room table or in a courtroom, but everybody's sitting together. The hearing officer will be there, the district representatives, the district's attorney, if they're represented by an attorney, which they typically are, and you, and if you have an attorney there present or an advocate. And then there will be a court reporter who takes down every single thing that is said during the course of the hearing. So typically the hearing begins by the hearing officer doing introductions and talking about the ground rules and how things will work. And then you have an opportunity for an opening statement. At that time, either you or your attorney will go through the background of the case and talk about what the issues are and what it is you're seeking. The district will then have an opportunity to do their own opening statement. And then begins really the evidentiary portion of the hearing. And your documents will already be there, and the hearing officer will have the documents, but then you really want to, at this point, you will be taking the testimony of various witnesses. The witnesses can be experts who have evaluated your child. It's typically one or both of the parents will testify. It can be family friends who have noticed a change, teachers who want to talk about what's happened. It really depends on the case. So you have an opportunity to do what is called a direct examination of your witnesses. And once you do a direct examination, the district has the opportunity to do a cross-examination, where they can ask the witness anything that was raised in the scope of your direct examination. And then you can ask what's called redirect questions, if there are things that were raised in the cross-examination that you'd like to address. So you go through all of your witnesses in that fashion, and then the district has an opportunity to present their witnesses, which is typically school administrators, school employees, teachers, ed techs, who, maybe they're experts. And again, you have the opportunity to cross-examine their witnesses. At the close of the evidence, when all of the witnesses have testified, there is then an opportunity for closing arguments. This is sometimes done orally or sometimes done in writing. When it's done in writing, you typically agree with the hearing officer on a time frame for submitting those written briefs, which typically outlines the statement of facts, and then the law that's applicable, and then your conclusions based on applying the facts to the law. And at that point, if the arguments are done orally at the hearing officer then has 15 days to submit a decision. If you are submitting written closing remarks, then from the time that those are submitted, from that deadline, the hearing officer then has 15 days to issue a decision, and that decision comes in writing and typically includes the hearing officer's findings of fact and then their conclusions of law. And then if the hearing officer is found in your favor, there will be a remedy that they're ordering.
A few last specific things you need to know about due process hearings. First, witnesses can be subpoenaed. You can ask the commissioner's office to get a subpoena. You're responsible for the fees and for serving the subpoena, but you can do this for witnesses who otherwise might not come voluntarily to testify. Second, at the time that you receive your decision, you may want to have a transcript of what happens. Parents are entitled to a free transcript from the court reporter of what happened at the hearing, and you need one of these if you are contemplating going to a judge for judicial review. And the last thing you need to know is that if you do have an attorney, this is the only dispute resolution process which, if you prevail, actually allows you to seek recovery of the fees that you have become responsible to pay the attorney for. Attorney's fees are not decided by the hearing officer, but if they cannot be negotiated with the school district, that you can file a petition with a judge to award you fees if you are successful in your due process hearing request. Thank you.